Fees, inactive status, penalty fees. The Commission is empowered to establish non-refundable fees paid by the licensees to fund the maintenance and operation of the Commission. All fees are deposited into the state treasury and include an examination fee. If the candidate fails the exam, they may take another by filling out another application and paying another fee. An activation fee. Renewal fees. Rules require all licensees of individuals to be renewed by the last day of the birth month every 4 years. In the event a license lapses due to failure to pay fees, the licensee may reinstate the license within 2 years by paying all renewal fees, late charges, and reinstatement fee. If the lapse is greater than 2 years but less than 5, the licensee may reinstate the license by paying all renewal fees, late charges, and a reinstatement fee, plus completing any education required by the Commission. If the lapse period is more than 5 years, the licensee cannot reinstate the license, but must requalify as an original applicant, including education and exam. If the license of a licensee is lapsed for greater than 1 year and the license was not subject to CE, upon reinstatement, the license shall be subject to CE requirements. Should a person not wish to be actively licensed, they may make a written request to the Commission to have their license placed in an inactive status, and the request must be made within 30 days of ceasing work for a broker. While inactive, the licensee may not engage in any brokerage activities except for property they own. To reinstate their license, they must obtain the signature of a broker who agrees to be responsible for their license and activities. While inactive, the license must be renewed each period with renewal fees paid to the Commission. To reactivate the license, the licensee must complete CE courses equal to what would have been required if they had maintained an active license. Penalty fees, not to exceed the renewal fee charged to brokers, may be imposed on a licensee who fails to notify the Commission in writing within 30 days of a change of address, the opening or closing of a trust account, transfer to a new company, or departure from a firm to go inactive. Fails to affiliate with a new company or go inactive within 30 days of being notified by a broker that they no longer wish to hold the license. Fails to respond within 30 days to a Commission inquiry. Submits a check to the Commission that is returned unpaid. The fees collected by the Commission shall be deposited in the state treasury, and the expenses of the Commission shall be paid from these funds. Power of the Commission to issue, revoke, suspend, and censure. The Commission is empowered by law as created by the state legislature to regulate the issuance of licenses, revoke or suspend licenses, and may enter into contracts with others, such as CPAs or forensic accountants, to assist in the examination of brokers' trust accounts. The Commission may grant a license to a person who has a reputation for honesty, trustworthiness, integrity, and competence to do business in such a manner as to safeguard the public's interest. The Commission may deny license to a company if any member, stockholder, or partner with more than 20% of the ownership of the company does not have said qualities, or if such persons have been convicted of any crimes. Crimes sufficient for refusal of license: forgery, embezzlement, obtaining money under false pretense, theft, extortion, conspiracy to defraud, crimes involving moral turpitude. An applicant for licensure as an associate broker or broker who has been convicted of any of these offenses cannot be licensed by the Commission until at least 10 years have passed since the conviction or release, whichever is later. There are no pending criminal charges. The applicant provides satisfactory proof that they now have a reputation for honesty, trustworthiness, integrity, and competence, and will conduct business in such a manner to safeguard the interest of the public. Power of the Commission to issue, revoke, suspend, and censure. Making false statements on the application are grounds for refusal to issue, suspension, or revocation. It's better to disclose all pertinent information to the Commission. Any sanction by an occupational body of Georgia or any other state can also be sufficient grounds for refusal. This could include a medical, nursing, cosmetology, law, engineer's license, etc. The licensee must immediately notify the Commission upon conviction of any of these crimes. The license shall be automatically revoked in 60 days unless the licensee makes a written request for a hearing. Two other offenses that may be cause for refusal to issue a license or suspension of a license are non-compliance with a child support order, default on a student loan guaranteed by the Georgia Higher Education Loan Program, refusal to issue. The Commission must provide a hearing in accordance with the Georgia Administrative Act if it refuses to issue a license after a proper application. If the applicant is not satisfied with the final decision after the hearing, they are entitled to a judicial review in accordance with the Act in the Superior Court of the county where the Commission is located.